welcome our first speaker, Mohamed Elghatit, founder and co-managing partner of OGH Legal UAE. Previously, Mohamed was the director of the DIFC LCIA Arbitration Center, and before that he was the acting leader of Hogan Lovells Middle East Disputes Practice in the GCC. Please.
Good morning, everyone. There's no doubt, I hope, in anyone's mind that arbitration is and will remain, at least in the neighboring jurisdictions, a very fluid topic. Primarily because there is definitely an intention behind the developments that have been taking place in the region, and most importantly in the UAE, to promote the use of arbitration and to streamline the user's ability to utilize arbitration as a means for settling the disputes. Now, some years ago, that was not the position in the region. There's no doubt that during the 1950s and 60s, there were a number of unfortunate, I would call simply misguided awards issued against a number of Arab states, 1950s, 1960s, and even the 1970s. So that led to what I believe was a very justifiable apprehension, not only by Arab governments, but also Arab companies and Arab joint ventures towards the use of arbitration as a means for settling commercial disputes. Now, as all of you will know, that has significantly changed. That initial apprehension was alternated with a newly found acceptance and even sometimes preference towards arbitration. A very interesting development, and we can talk about its positive or negative effects at another context, but it's a very interesting development because it shows how much of acceptance the regional governments in the Middle East have towards arbitration. There has been a significant proliferation of arbitration institutions in the region, opening up of branches of international institutions in the region. And many of them, as you will see, are actually joint ventures between private and public sector institutions. So that of itself confirms that there is that newfound preference and acceptance towards arbitration in the region that has been taking place since the 1990s, but now definitely very prevalent. So I thought it would be interesting and hopefully helpful for me to take you through one of the primary developments that have recently taken place, which shows a continued and extended attempt by the local governments, by the local institutions to promote the use of arbitration as a means for settling commercial disputes. That particular development I will run through is the awaited launch of the new Deaq arbitration rules. Now, many of you will know that Deaq is one of the largest institutions in the region, at least in relation to case volume. So it's very important and indeed interesting to see what those new rules will come with. Those new rules should be coming up early in 2018, or so we are told. So I'll take you through a few main features of those rules and highlight how they're actually very positive, not only because they bring those rules up to the international standards of their counterparts in other jurisdictions, but also because they are tailor-made to resolve issues that have arisen locally, either because of local court decisions or because of gaps in local law. So I think it should be a very welcome development. So let's start by a few easy points. English will be the prevailing language in the rules. Now, some of you could say, well, that's quite plain vanilla. What is interesting about the rules being in English? Well, what's interesting is that those Deaq rules are actually issued by means of an immediate decree. So they're law. The fact that the prevailing language of the rules will be English is quite an achievement. Now, the old rules have also had that facet, but it's, again, reassuring that this continues to be the case, and the new rules in English will take precedent over their Arabic original version. The second interesting development is that the new rules provide for a default seat that is DIFC. Now, many of you will know that parties in their arbitration agreement should, if they're well advised, agree on the place of the arbitration, the legal seat of the arbitration. But many a times, parties either fail to agree or simply forget to agree on a place for the arbitration. The new rules now state that the parties' lack of agreement and the default seat in that event will be DIFC. Now, what is particularly interesting in that default seat choice is that with the choice of DIFC, you bring in the DIFC courts. Many of you who have been working in the region or following regional developments will know that local municipal Dubai courts have slightly been unpredictable, slow, delayed in relation to enforcing arbitral awards, or even for considering the manner in which to assist the progress of an arbitration proceeding. But if you have your seat of arbitration in DIFC, that means that you have direct access to DIFC courts. The panel on DIFC courts are made up of retired English court judges, we assume are more amenable to arbitration, and accordingly, their track record has been to date impeccable in respect of recognizing and enforcing arbitral awards, and also in relation to what they call precautionary measures or urgent measures to be taken by parties during the course of arbitration to assist with the progress of arbitration. So that's in itself a very positive development. Another very interesting development is the seat of arbitration. Now, those of you who have been involved in Deaq arbitration will know that sometimes when you choose a foreign arbitrator, they have to fly in all the way back to Dubai to literally simply sign the award. That has been removed with the new rules, and the arbitrators are free to sign the award wherever they are, and still the award will be considered as being issued in the UAE. Another interesting development is the institution of the ability and rather obligation of the DIAC Secretariat to review and scrutinize arbitral awards. That means that errors in arbitral awards will be avoided, issues relating to formalities that are required by local courts hopefully also will be avoided. So that is something that obviously Deaq have copied from the likes of the ICC, where indeed they have, or they've given their secretariat the power to scrutinize awards. So again, a very positive development aiming at ensuring efficacy and enforcement of the awards. Another set of developments, which I group together, is the introduction of various measures to ensure expedited and efficient management of proceedings. You have the inclusion of emergency arbitrators, by which parties can quickly get an award, an interim award on a particular issue, and letting the primary issues or the bigger issues being dealt with at a later stage. For example, contractors who have certified claims that haven't been paid yet, they can apply for an emergency arbitrator, get something at least partly dealt with in the beginning, and get their money. Expedited proceedings and the power to sanction counsel. Now, you've heard from the panel just before us that sometimes respondents adopt guerrilla-like tactics, to delay proceedings, to create complex issues and derail proceedings. Now with the new rules of Deaq, the arbitral tribunal, pursuant to the Deaq rules, has the power to issue sanctions against the respondents. These sanctions are usually monetary, so they can have cost implications, which obviously should, at least, dissuade or make it less attractive for respondents to try to adopt those guerrilla tactics. Quickly moving on, the new rules provide for ability for parties to consolidate arbitral proceedings. All of us will have been involved in cases, particularly in the real estate sector, where you'll have a number of arbitrations all relating to the same transaction, but because they're under separate contracts, you have to file separate arbitration proceedings. Now, with the new rules, subject to satisfaction of certain conditions, you can consolidate those proceedings. Quickly on third-party funding, that I understand is the only not yet completely confirmed new aspect of the new rules. But again, the mere mentioning of it potentially coming in is very comforting, because it shows how Dubai and the UAE is very keen on promoting arbitration, not only optically, but rather providing the tools for the users to be able to properly utilize and exploit the use of arbitration as a more efficient means for settling commercial disputes. Quickly, you'll be happy to know that this is the last slide. Immunity for arbitrators. Now, many of you will have known or heard about, particularly in the Middle East, where parties sometimes take it a step far and sue arbitrators sometimes. I'll focus on the civil part because I know that my learned friend will cover the criminal part, but in the civil aspect, the new Deaq rules provide for full immunity for the arbitrators. Again, people will say, well, that's standard in other jurisdictions. Possibly. But in this jurisdiction, it's not standard. And the fact that Deaq has taken that step is, again, a very positive indication. Quickly, what is next for Dubai? I think all of us who have been involved in conferences that have included topics about arbitration, there's also always a mention or two about the arbitration law. What is next? Well, hopefully, is the arbitration law. Whether that happens or not, well, no one knows. Thank you very much.